Right. Can we lose her on the way? She hasn't got lost. Yep.
Gerald Dworkin. Gerald Dworkin used to be IP professor. But I knew him in the 80s. Is he still alive, or is?
Do you know? Embarrassing. I'm not sure. He was a groundbreaking.
He was, yes. Because Roy Good was at Fishcons, and then he introduced us.
Welcome those of you who are physically here, and welcome those of you at the other side of that camera. This is the first live event we have had at IBIL since lockdown. The university lockdown about 10 days before the government, the day after our event. We're very lucky to be able to run this. And the first rule for all of you is all phones off, or you are in deep stum. We have methods here, Watson. My second job is very simple. It's to hand over to Anthony Julius. And his job is quite simple, because he's going to get this lot to talk. And they're quite talkative. Thank you.
Thank you very much, Robin. As you correctly say, my job is to hand over to our speakers. They're each going to speak for about 20 minutes or so. We've agreed between us that we will defer questions to any or all of them until the end, after the end of the third person speaks. So we're going to run straight through with 3 presentations. And that should still allow about 15 or 20 minutes for robust but economically expressed questions. It's my and our great pleasure to welcome as our first speaker Professor Jonathan Griffiths from a competitor, London University. He says not a competitor.
No, different division.
Jonathan, the floor is yours.
Thank you. Thank you, Anthony. And despite that, it's very happy to be here. I'm honoured to be here. It's interesting to hear that this is the first in-person event. This is my first in-person paper since before the pandemic as well, so it all feels a little unusual. There we go. So what I would like to talk to you about this evening, 20 minutes or so, are the absolute grounds for refusal under Section 3.3a and their hinterland, particularly in relation to accepted principles of morality and public policy. About 10 years ago, I wrote a chapter in Paul Torreman's book on IP and human rights, on the absolute ground for refusal under Section 3.3a and its European equivalents. And at that time, my interest was stimulated by repeated suggestions, sort of sporadic but repeated suggestions in the decisions on the provision that this somehow had to be viewed through the lens of freedom of expression. And I was interested, and I remain interested in the relationship between IP, including trademarks, and human rights, including freedom of expression. So that was really interesting. Generally, I spent quite a lot of time arguing that we needed to view freedom of expression a bit more seriously in IP law, particularly copyright and trademarks. But in this context, I found myself coming at it in a slightly different direction, and I argued that freedom of expression actually bore very lightly in Section 3.3a cases, and suggested that it ought to have very little role to play, despite what was said about it. Now, that was 10 years or so ago. It's amazing how quickly that's passed. And I'm conscious that since I wrote that piece, a great deal has happened on this topic. So Lisa's going to follow on and tell us about the seismic changes that have taken place in the US, where the problem of the relationship between the First Amendment and trademark law in this context has been cleared up in a very dramatic fashion, in some more cleared out. We've also had the judgment in Constantine film production in the Court of Justice, which remains with an impact in this jurisdiction, despite that other important development, Brexit, which has had a significant impact on the way in which fundamental rights are handled in the law in this jurisdiction. And if that weren't enough, we've had in that period a judgment of the European Court of Human Rights on this issue in Chibi in Romania, on the crucifix mark. We've had Vigeland from the EFTA Court. And given all that activity, you'll understand why I was very pleased to be asked to sit on this panel and to speak. Re-entering the debate a decade later has been a bit of a chastening experience, because while I remain profoundly relaxed about refusals to register marks such as fucked, fcuck, fuck, and fuck, I have to admit that I'm not too proud to suggest that I've been proven wrong. And subsequent developments indicate that at the very highest authority, actually freedom of expression is said to be relevant in such cases. And my presentation now is going to record my attempt to update, in a sense, where we are on this issue. And it's also a first attempt possibly to move away from the position I adopted before and to suggest a way of organising the law in this area. So what I intend to do, and you have to excuse me if this is familiar, is initially to outline the approach adopted in the UK traditionally to this issue. I'm then going to move on to talk about Constantine film, and then I'm going to consider some of the implications of that case and the issue more generally. So the established UK approach to the interpretation of Section 33A, and this is something that will be very familiar to many of you, derives from a series of well-known cases, predominantly, although not exclusively, I say that advisedly in this company, derived from appointed person decisions in the early to mid-2000s. It's interesting that there's been, listed on that slide for you there, it's interesting that there's been relatively little domestic activity subsequent to that. I mean, I guess that's because the game moved to Alicante to an extent for a period. And the most concerted attempt to rationalise the principles emerging from this body of case law, unsurprisingly perhaps, came from Richard Arnold QC, appointed person as he was at that point, in Woodman and French Connection, you can see there, in which he had to consider a case in which an applicant, considered the registration of French Connection's FC UK mark, which was challenged as being invalid, as having been registered in breach of Section 33A. And he carefully summarised the principles which need to be applied. And this is, he said he was distilling those from the pre-existing case law, so he was attempting to find out what the law said so far and to move on from it. And this is, on the next couple of slides, I've set out a selection of the highlights. So when we're considering whether a mark is contrary to accepted principles of morality, because that's the particular aspect of Section 33A that he was interested in, he said you had to focus on the intrinsic qualities of the mark rather than the behaviour of the applicant. He said, and this is important particularly from my perspective here, he said that the interpretation and application of Section 33A had to be consistent with the right to freedom of expression under Article 10. And importantly, that any doubts on its application had to be resolved for the applicant. looking at, further, he said that the use of the mark shouldn't contravene generally accepted moral principle. That was the overarching principle. And mere offence and distaste was not enough. This is something we hear repeated very frequently. And the provision would only apply where use of the mark would justifiably cause outrage amongst an identifiable section of the public, particularly as being likely to undermine current religious, family, or social values. He also noted that different considerations might apply to different categories of mark. So we might think differently about a mark that incited violence, let's say, from one which was just smutty. Importantly, he said that evidence could be looked at in deciding whether a mark caused outrage or not. So this wasn't a purely normative inquiry. It was possible to seek and see, particularly where a mark had been used, how reactions to that mark had come. What's quite interesting is that in his distillation of the principles, there are actually a couple of potential tools in the earlier jurisprudence that he doesn't mention. So he doesn't mention the possibility that the right-thinking member of the public might be an assessment tool. That's interesting. That's in basic trademark, that was said, and it's mentioned still in Curley. But he also doesn't mention the fact that in Gazillion, the tiny penis case, it was said that a higher degree of outrage or censure amongst a small section of community might in some instances be enough to bring the provision into play. So that's a sort of whistle-stop tour of what, most leading textbooks on IP law, on trademarks now, would describe these as the binding principles. What I found quite interesting, coming back to this after a period, was to go and to look and see what further decisions had been arrived at in the intervening period. And there are a number, not that many, but there are a number of predominantly hearing officer opinions, views on decisions on various applications and oppositions. I haven't got time to go into them all in detail, and I would have said that I will do so if I get a chance, but I doubt that I'm going to do that. But so there are a series, which hopefully the references might be of interest to you. What's interesting in all of these cases, the UK cases, is that despite the fact that in French Connection it was said that freedom of expression is supposed to form a framework for the decision-making process, that is not the case in any of those decisions at all. Indeed, freedom of expression is not mentioned in most of those cases at all. It's mentioned in passing in the case, the addicted case, which was the case where the Adidas logo was converted into a marijuana leaf, and it was mentioned in the Jack Shit case simply as reinforcing the decision that the hearing officer had come to in any event. So interesting to see that the message that this is supposed to be the dominant framework has not got through particularly to decision makers. Or maybe it's that decision makers don't know what to do with this idea that freedom of expression is in some ways supposed to govern and guide how the decisions are taken. Okay, so that brings us much more closely up to date, requires us to consider the recent important judgment of the Court of Justice in Constantine Film, which, as many, if not all of you, will be aware, concerned an application to register at European Union Trademark Office the mark Fuck you Goethe, which was the title of a German film comedy. It was attempted to be registered for a very, very wide range of goods and services in many, many categories. And the office rejected it. That rejection was upheld by the Board of Appeal, and the General Court refused an appeal against that rejection. And it was rejected on the basis that fuck you was equivalent to the English phrase fuck you, and even if that wasn't sexual in this context, it was shocking and vulgar. And the fact that Goethe had been dragged into it was an additional level of problem for the office. The applicant appealed to the Court of Justice, and this is the case with which I'm interested in now. This judgment, the Court of Justice, still has impact in this jurisdiction because of the Brexit settlement. I mean, UK courts, UK offices need to take account of what was decided in this case. So it's important in framing how we look at this question in this jurisdiction now. So on the next few, I've got a clock in my eye up there. On the next few slides, I set out a number of important aspects of the Court of Justice's judgment. In the interest of time, I'm going to summarise a number of those. Hopefully, I don't know if this is true, whether the slides are made available more generally. So hopefully, those of you that aren't, I mean, many of you will be familiar anyway, but those of you who aren't, hopefully those will be useful. In essence, what the court did, it defined accepted principles of morality as fundamental moral values and standards to which a society adheres at a given time. And vitally, it found that those standards need to be determined according to the social consensus that prevails at the time of assessment. That is, a concrete assessment needs to be made based on available evidence, rather than an abstract, unsubstantiated view of the decision maker. And the court suggested that, in fact, that's what had happened in this instance. There'd been insufficient reference made to what was going on in the real world, rather than to the decision maker's sense of what was morally appropriate. On the facts, and using that test, the mark was held not to violate those values and standards, because evidence suggested that this film, Fuck You Goethe was the title of the film, had been viewed millions and millions of times without complaints. Indeed, even the Goethe Institute, ironically, prescribed it for people visiting it. So on that basis, it was impossible to view it as falling below the standards, despite the use of the word. So, having come to those conclusions, what I want to do, though, is what's important from my perspective, is what the court said about freedom of expression and fundamental principles of morality. So if we move through those slides that I promised to skip, what the court said was that correcting the General Court and the Boards of Appeal, who had suggested that freedom of expression and applying for a trademark had nothing to do with one another, that was in fact not the case. And in fact, freedom of expression enshrined in Article 11 of the Charter must be taken into account when applying Article 7.1f, which is the regulations equivalent of 3.3a. And in coming to that conclusion, they followed the Advocate General. I mean, this is pretty much all that the court says. The Advocate General had said a little more. He said that clearly you have to take freedom of expression into account because it has a fundamental role in the structure of the union's legal system, that even commercial speech was covered by this right. You can't simply say that the very existence of Article 3.3a delivers compliance with the right, and therefore we have to take it into account when deciding whether a mark should be admitted to the register or not. At the same time, the Advocate General said free speech wasn't the primary goal of trademark law and didn't say precisely how this was to be dealt with at all. He refers, without approving necessarily, the argument of the applicant that reliance on Article 11 called for a slightly more liberal approach to be taken to the test of accepted principles of morality. But that's just left, that's left hanging. So what we've got is we've got acknowledgement that this is important, but we haven't got any indication of exactly what we're to do with it. So what about responses to that conclusion? And I'm going to skip another slide here because that's responses to other aspects of the film, the slides I jumped. What about responses to this conclusion on freedom of expression? Well, a number of commentators, some in this room, have noted that the relevance has been acknowledged, but the impact on methodology and outcome remains uncertain. It's possible that the acknowledgement that freedom of expression was significant led to the Court of Justice's liberal approach to the application of Section 338, but we don't know that for sure. So this is a very strange situation, it seems to me, and it's certainly not satisfactory. It seems to me what we need to do is to move on to a more structured approach to the relationship between those two rights. And we can do that by viewing the issue through the lens of Article 10 a little more considerately. And I think if we're to do that, we'd come to a number of conclusions which might tell us a little bit more in detail about the nature of this relationship. So firstly, we'd find, if we look at the case law in Article 10, we'd find that some forms of expression are actually excluded from consideration. So, for example, those that seriously draw into question the rights under the European Convention, they're not protected. So, I don't know, a mark that advocated terrorist activity, for example, wouldn't necessarily be protected. But similarly, under the case law in Article 10, insults, so pure insults, are also not likely or very, very limited in terms of the protection that they receive. So that's significant there. If we're looking at this through Article 10, we always need to ask if there's an interference. Well, of course, there's a limited interference, isn't there, in relation to Section 338, because the person applying for the mark, even if their application is refused, are still able to use that mark. We'd need to ask whether the interference that's been made in a particular instance serves a permitted purpose. Here, interests of public safety, territorial integrity, the protection of health and morality are likely to be the areas that are most relevant in this situation. We'd also need to be sure that the interest is prescribed by law, the interference. That's likely to be okay, because if we clean out and organise the law in this area more effectively, that's the test for prescribed by law is a very loose and relaxed one. What I think is going to be more interesting here, though, is how do we deal with the proportionality analysis? So in this instance, I think we need to start to distinguish between different categories of protected mark. So, for example, we might need to distinguish between a mark like Facu Goethe, where there is an artistic or creative aspect to it, as opposed to something that is pure commercial speech, that is a pure insult. We've seen plenty of examples of those. They wouldn't necessarily be considered from this context very strongly at all. We need to look into the detail of the fundamental case law in those particular areas. So, for example, we might have to reconsider the Jesus case, where the mark was refused, on the basis that it was effectively simply a religious term. And we might need to ask whether, in fact, the European Convention's case law on religious marks simply allows the use of a name like that to be rejected, or whether, in fact, more evidence of harm to the population more generally might be required. We might also need to take into account the fact that a mark has been used as a relevant factor in this proportionality analysis. Certainly it's a notable feature that a number of the cases in which courts have held that apparently indecent marks should be allowed to be registered are in situations like FC UK and like Facu Goethe, where use has taken place already. And I think that's significant, because I think that's not only about evidence that this is a proper word. What's also important there is the fact that there is a stronger interest in having a mark protected if you've used it. And I'm conscious that I'm running out of time. And in the last minute or so, I think that's available to me, what I suggest in this more developed piece is that we actually ought to take a two-stepped approach to applications, Section 33A under the morality head, in the light of freedom of expression. And I think what we need to do to understand Constantine film properly is to do the contextual analysis as the first step, that is to ask whether something violates the principles of morality in a social context as it stands, and then if that is failed, and I think that will be in very few cases that we will need to do this, but if step one is failed, then we need to check whether issues raised by the applicant's right to freedom of expression need to be taken into account in any event. This, I think, will organise the approach of courts, which at the moment is not organised at all. Okay, so thank you, and apologies for running over my allotted time.
No, thank you. You actually were bang on.
Or was I?
So can I now, with great pleasure, introduce Lisa Ramsey, who's a professor who's come over from the University of San Diego to speak to us this afternoon.
Thank you for having me here. I am very delighted to be here. Thanks to the University of College London for inviting me. I have been writing about trademark law and how it potentially can conflict with the right to freedom of expression for about 20 years now. And mostly my work is focused on the problems with registering things like descriptive terms or common slogans, or strong enforcement of trademark rights, prohibiting others from engaging in dilution of famous trademarks, for example. But recently, a couple years ago, in the Tam case, the Supreme Court, for the very first time, applied the First Amendment to trademark law. And it was a very interesting situation because it was someone arguing that they had, in a sense, a free speech right to register a trademark as opposed to a free speech right to use certain language protected as a trademark. So this is the Lanham Act provision. Lanham Act is the federal trademark law in the United States. And Section 2A of the Lanham Act bans the registration of any mark that consists or comprises immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection, right, with persons, living or dead, institutions, beliefs, or national symbols. This law has been used to refuse to register hate speech, curse words, other kinds of language and symbols that may be offensive to some folks. Some people are fine with curse words, but the Trademark Office had refused registration to a number of these kinds of marks on the ground that the applicant could still use the mark, even though they couldn't register the mark. Now, the right to freedom of expression in the United States is in the First Amendment of the U.S. Constitution. And before the Tam case, I and others had argued that the fact that you can actually still use a trademark even without registering it means that perhaps there's not as much of a First Amendment problem here. In fact, if we register political messages, social messages, curse words as trademarks, then the registrant can stop a number of other parties from using that language in the same way as the registrant and in different ways, since trademark laws can apply to identical or similar marks and in connection with identical goods and services, but also different goods and services. But the Supreme Court didn't agree with my conclusion that this law was not so much of a problem. In the Tam case, this is the person that's, I think, the second from the front. His name is Simon Tam. He kind of is the leader of a rock band called The Slants, and he applied to register The Slants as a trademark for the entertainment services of his rock band. All of the members of the band have always been Asian American, and they sought to register this mark, The Slants, to kind of reclaim this slur, which some of you may not know, the slanty eyes is kind of a derogatory term used to describe some people of Asian descent. And so they thought that they would reclaim the slur and drain its denigrating force. And the Trademark Office refused to register this mark on the ground that it may disparage people of Asian descent. So they appealed the case to the Federal Circuit. Initially, the Federal Circuit affirmed this decision, saying, well, you can still use this mark, you just can't register it. But then the Federal Circuit heard the case en banc and actually held that the law was an unconstitutional restriction of expression, that it chilled speech protected by the First Amendment. And then later it goes up to the Supreme Court, and the Supreme Court agrees that this is an unconstitutional law. What the court said is that this law discriminated based on the viewpoint of the expression. The Trademark Office was willing to register terms that were celebratory of Asians, but it refused registration of terms that were critical of Asians. And in the United States, if a regulation of speech is discriminating based on viewpoint, that's pretty much fatal. Although sometimes laws are okay, but mostly it's fatal. So the government basically conceded that if this was a viewpoint discriminatory law, that it would be unconstitutional. This was a big deal in the trademark and free speech community because the court also said that hate speech is protected by the First Amendment. This is not true in a number of other countries. And so, so after this, I wrote a paper called Free Speech Challenges to Trademark Laws After Mattal versus Tam, where I kind of walked people through the decision, because there are a lot of interesting issues that come into play when you try to apply the right to freedom of expression to trademark law. And I have a slide later which I will go through the kind of the issues that you want to be thinking about in this context, not just in the United States, but in other countries as well. But I argued in this Houston Law Review article that this case basically opened the door to a variety of free speech challenges to trademark laws. A lot of folks thought that one of the next provisions that might be held unconstitutional is the provision banning registration of immoral and scandalous trademarks. Now, as a result of the Tam case, the Redskins marks, right, which had been registered and then had been canceled as a result of the efforts of Susan Harjo. Well, actually, initially, Susan Harjo, pictured here, had challenged the marks, but there was a problem with latches. She'd waited too long to challenge them. So another Native American woman, Amanda Blackhorse, then challenged the marks, and they were canceled by the Trademark Office. It went to the Eastern District of Virginia, heard this case and affirmed the refusal on disparagement under the disparagement provision, and the case was being considered by the appellate court. I think it was the Fourth Circuit. And around the time the Tam decision came in, was up at the Supreme Court. The Supreme Court refused to accept an amicus brief from the team, the Washington football team. So the court just heard Tam's arguments in that case. And Simon Tam and Amanda Blackhorse were all on a panel together at INTA in 2018, and afterwards I got a picture with them. These are some of the attorneys that represented various parties in the case. The gentleman in the middle, Stephen Bird, I believe, represented Susan Harjo. But let's say it was a little bit uncomfortable because you have Simon Tam, who basically got this law struck down, and now the Redskins mark would not be canceled as a result of Tam. Although you may have heard in the news that the team decided to change its name anyway, right, to the Washington Commanders. And a number of other brands in the United States have decided to change their logos and do other things to try to not use terms that may disparage others. So that's the Tam case. And so as I mentioned before, some folks said, well, maybe this immoral scandalous mark provision might be struck down. And it was in the Brunetti case. So this is Eric Brunetti. He's a street artist. He sells clothing. And he applied to register the letters FUCT for apparel. He claimed these letters stood for the phrase, friends you can't trust. But everyone pretty much thought, now he just wants to evoke the word fucked, right? And so here are some pictures of the specimens of use that he submitted to the trademark office showing his use of the mark on products. These are decorative uses, right? You have a dog who's bitten somebody's arm off, right? That person is fucked, right? So I think I would argue that this is not really acting as a trademark in this context, although I think he did become very well known, especially as a result of the case. And what the court said is that this law is also a law that discriminates based on the viewpoint, and struck that down. Although this time you had a couple of justices that said, well, wait a second here. He can still use the mark, right? So maybe we should be thinking about that. And about three justices said, well, we might be able to ban obscene expression, maybe expression that is highly vulgar, that is profane. And so it's interesting. It makes you wonder if Congress actually revised the law, perhaps it would be upheld by the justices, especially given the current makeup of the Supreme Court. So after this case, a number of people applied to, actually after Tam, but also especially after Brene, applied to register curse words. And so when I did a search last Thursday, April 21st, there were 889 records that had the word fuck in it. Of those records, 5 of them were applications to register fuck by Eric Brene, right? So he wasn't just going for fucked, it was for fuck as well. And these include apparel, right? But also, I think, maybe watches and other kinds of accessories. What I call, in a paper I'm working on, expressive merchandise, right? The kinds of things that you might wear to express ideas. So at this point, there has not been a final decision on these applications, but I think that the Trademark Office will probably refuse to register this phrase on the ground it fails to function as a trademark. We have seen this happen in other contexts. So after the Tam case, this African-American gentleman pictured here applied to register the N-word and the swastika for various kinds of products. He claimed his goal was actually to prevent other people from using these offensive words or symbols. And all of us trademark professors and attorneys are like, that's not how trademark law works, but there you have it. So he applied to register these marks, and the Trademark Office has now shifted to refusing to register these kinds of marks on failure to function grounds. Now, in the United States, this is not something that's explicitly in the statute. You see this in the Trademark Manual of Examining Procedure. Basically what it does is it points to language in the Lanham Act that says that a trademark needs to identify and distinguish the source of goods and services. And so that's the statutory authority for failure to function doctrine. Because the argument here is if you have a phrase that is providing information, if it's a political message, a social message, an offensive message, or you're using the mark in an ornamental or decorative way on the front of a t-shirt, for example, that these kinds of uses of language or communicative symbols fail to function as a source identifying trademark. And so Alex Roberts has written a great article called Trademark Failure to Function, which notes that this is different than distinctiveness doctrine, right? So you might have a registration for a phrase like lifeguard for apparel. That is arguably a strong mark for apparel, right? It's not descriptive, it's not generic. It's an arbitrary mark for apparel. But at the same time, I would argue it fails to function as a source identifying trademark. Unfortunately, in the United States, that registration has been registered for more than 5 years, and the registrant's right to use the mark is incontestable, meaning that you can't challenge it on lack of distinctiveness ground or on failure to function grounds. So there are the provisions of the Trademark Manual of Examining Procedure that talk about this. It's also called use of subject matter as a trademark. And so again, there's a provision about refusals based on ornamentation, the fact it's decorative. So here are some examples. Somebody applied to register "I love you" for jewelry. And the Trademark Office said that you could not register that under failure to function doctrine. Also, I guess that caused confusion with another mark. And then we have this application to register a design on the front of clothing that was also deemed to be ornamental. The informational matter refusal has been invoked quite recently by the Trademark Office for applications to register political messages, social messages. It might also be invoked if you have trying to get rights to a religious phrase, for example. And if it's a widely used message, it's more likely that they'll refuse it. So often people will submit evidence to the trademark office using letters of protest. This is a procedure we have in the US, saying, look, there are a lot of people using this phrase on the front of t-shirts, trademark office, for reasons of competition, free speech, you shouldn't register this. And so luckily they've been doing this in a number of situations. And so John Welch has written about these kinds of refusals, right? Once a Marine, always a Marine, I Heart DC, right, have been refused registration on this ground. Although I Heart New York, NY, was registered years ago, and the registrant's right to use that mark is incontestable. So that can't be canceled at this point on that ground. So for the swastika, the trademark office refused to register that. In a non-final office action, we'll see if that's going to be reversed by the TTAB. With regard to Brunetti's application to register, that was actually, with regard to the fuck marks, they did refuse that on failure to function grounds at a final office action as well. So that's a problem for Brunetti, and then the N-word also, that was also refused registration on failure to function grounds. And so a number of attorneys who had wanted these marks to be registered were a little bit frustrated now that they're using the failure to function doctrine to refuse these marks. But I think it's the right result, because in the end, right, these kinds of messages communicate information, ideas, right, and they should be available for anyone to display on the front of a t-shirt. I would hope people wouldn't for hate speech, but for curse words, anyone should be able to put the F word on the front of a t-shirt, right? And so, so that's the failure to function doctrine. So next I'm going to just briefly talk about kind of the implications of Tam and Brunetti and how you might approach a challenge to a trademark law under the right to freedom of expression in the United States, but also other countries as well. So first of all, you need to make sure we're talking about government action, right? This is the government that's enforcing trademark rights or refusing your trademark registration. If Facebook decides to delete your account or delete a post, some other online service provider does that, Amazon, right? That's private action. That's not a First Amendment violation, even though it harms your expression by having that taken down. Number two, the trademark law has to ban, punish, chill, or otherwise harm expression. So it's not just laws that ban speech, but also laws that might prevent you from speaking because you're worried you're going to be sued. And then three, the trademark law regulates expression protected by the right to freedom of expression. So it used to be that some courts would say that trademarks are conduct or economic activity, but it's very clear after Tam that trademarks are expression. And I would argue it's not just when they have political or social messages like the slants, right? But also when they're communicating information about the source of goods and services, right? That's commercial speech, but commercial speech is protected by the right to freedom of expression. The expression has to be private speech. Some folks had argued that when you register a trademark with the PTO, it becomes government speech. And in the US, you can regulate government speech on the basis of its viewpoint. But Tam rejected that argument and said that at least for private trademarks, it's not government speech. Obviously, if the government has a registration, they can decide not to allow the use of a disparaging slogan. The expression has to also not be categorically excluded from protection. So if you are banning registration of obscene trademarks, that's going to be okay under the First Amendment, as long as you're not discriminating based on viewpoint. Also, bans on registration of deceptive or fraudulent, misleading uses of trademarks, that's all going to be okay under the First Amendment as long as you're not discriminating based on viewpoint. And I think in other countries as well, you can regulate this kind of expression. Also, you have to consider whether the regulation fails the relevant constitutional balancing test. So in the United States, if we're talking about non-misleading commercial speech, it's the Central Hudson Intermediate Scrutiny Test. Now, this is not toothless. There have been laws that have been struck down under this test. And in Tam, 4 of the justices argued that this law didn't even satisfy intermediate scrutiny. 4 other justices said that it should be subject to heightened scrutiny. However, in the First Amendment jurisprudence, the highest kind of scrutiny is strict scrutiny. Justice Kennedy kind of has suggested maybe rigorous or more heightened scrutiny for content-based regulations of non-commercial speech, but in Tam, for regulations discriminating based on viewpoint or ideas. Also, some judges have argued that these laws banning registration of disparaging, immoral, scandalous matter were vague, right? There were inconsistent decisions at the trademark office. I would argue this is a big problem in trademark law generally. It's often very hard to predict whether or not speech is allowed or prohibited under the traditional likelihood of confusion test, which has many factors. It's maybe difficult to decide whether or not a certain defense applies. So in the US, there are a number of provisions that are probably fine after Tam and Bernetti, right? Provisions that ban registration of matter that is fraudulent, misleading, deceptive. Those are going to be okay. As are provisions that promote fair competition and help consumers identify and distinguish goods and services, right? Like descriptive requirements that descriptive terms cannot be registered unless you can prove acquired distinctiveness, the functionality, exclusion, etc. Ones that are not so clear, right? The ban on registration of flags, coats of arms. This is required by international treaties. One of the goals of US law is to comply with international treaties, so we'll see if there's a challenge to this law. But Section 2C bans registration of a name, portrait, or signature of a living individual, a deceased US president during their life without consent. And this law was raised to reject applications to register marks that had Trump's name in them. And then we have 2F, right? This is the dilution provision. So Nike was able to stop someone from registering Just Believe It for business consulting services under the dilution provision. Now, for that Trump refusal, the Federal Circuit in Henry Steve Elster just recently held that application of this law, 2C, actually violated the First Amendment. So Stephen Elster, they talked a lot about the fact that this law was trying to protect the right of publicity, right of privacy of individuals. But the Federal Circuit said, well, this is political speech. We can't regulate, we can't chill this expression. What was frustrating to me about Tam and Bernetti and Elster is they didn't talk about the fact that registration can also chill expression, right? Prevent other people from using it. So I'll let you can read the blog post that I wrote about this to find out what Trump too small means. But I'm going to move on since we're short for time. After Tam, a number of folks argued that dilution law is probably unconstitutional in the United States. Not just the tarnishment provision, which applies often in the context of offensive expression, usually cases involving use of mark with goods and services relating to sex or drugs. But what's important about this law is you don't have to prove that the use is misleading, you don't have to prove that it harms competition, and you don't have to prove that there is any actual economic injury. And under First Amendment law, damages can't be speculative, right? You actually have to prove that there is a problem that you're solving and that there's actually evidence of harm that's being alleviated by this law. So I think a lot of people think that tarnishment might be struck down because it usually is used to stop offensive uses of trademarks. But I think blurring might also go down because blurring law prevents the registration or use of marks that might diminish the distinctiveness of the brand. In other words, it's an inconsistent message that you're communicating, something that's different than the brand image. So I think there's some good language in the cases to support this argument. And Rebecca Tushnet and has just submitted an amicus brief in a New York court case involving these Vans shoes that basically argues that this law is unconstitutional. So we'll see what happens. And I signed that amicus, so we'll see what happens with that. So I've written about these topics in a number of different articles, and I'm hoping that courts will continue to consider the fact that the First Amendment, right to freedom of expression, does apply in the trademark context, but my concern is not so much about allowing people to register marks. It's allowing people to use language or communicative symbols, right, to convey ideas, information in the marketplace. So I'm just going to end this presentation by talking about some actual and potential defensive doctrines and trademark statutes and the common law. So some countries have these, some don't. Most countries, though, do require a trademark to be distinctive and used to identify and distinguish the source of goods and services. You don't want to register a generic term or a term that's abandoned, that hasn't been used. Some nations refuse registration of matter that's ornamental, informational, expressive, right, functional. Black Lives Matter for T-shirts, that was refused, as is I Love You. Usually you have to prove that the use of the protected mark is likely to cause confusion for an infringement claim, not so for dilution. Commercial use of the mark is required in some jurisdictions in the US, but not all. In Europe, my understanding is that it is required. And a trademark use of the mark is required in some courts, but not others. In Australia, this is a statutory requirement. In the US, we have a doctrine that applies for uses of a mark in the content or titles of artistic and literary expression, the Rogers balancing test. It's a higher standard of proof that you have to satisfy to win. Successful parodies are less likely to be found infringing. However, if you're engaging in what we call in the US satire, right, commenting on society and not the trademark owner, you might not fare so well. Fair use of descriptive terms or personal names is allowed, although this is a pretty narrow defense, at least in the US. Comparative advertising is allowed in a number of jurisdictions, either because of the statute or in the common law, and other nominative fair uses of the mark where you refer to the trademark owner. And some courts even say that if it's fair use to just display a phrase on the front of a t-shirt, like "let us turn up the beat." But in the end, I hope that if we add more defenses to trademark statutes, more defensive doctrines, right, limitations on the scope of rights, that it will help further trademark law's goals, promote competition, but also protect freedom of expression. Thank you.
Our third speaker, Darren Meal, practitioner and part-time judge.
Hi, so I'm talking about bad faith, which may or may not be about morality. I'm not sure, maybe it is. Start with the basics. So for those who want to know the provisions, Article 59 of the EU Trademark Regulation, Article 4.2 of the Directive, and Sections 3.6 and 47.1 of the Trademarks Act. Under the UK Act, you can oppose a trademark registration and you can invalidate a trademark registration, oppose an application, on the grounds of bad faith. At the EU trademark level, you can only apply to invalidate an existing registration, you can't oppose one, and under the directive it's up to member states to decide whether you can or can't oppose. I'm not entirely sure for the reasons for that. Bad faith is not defined in those provisions. You won't find any definition other than the words bad faith. So we define it in case law. There's never been an exhaustive definition, so it's quite a broad principle. It covers things I'm not going to talk about today, so I'm not talking about where I register your trademark before you get a chance to do it, sort of trademark squatting. I'm leaving that out. What I'm going to talk about are actions that on the face of them might seem completely legit, but because of the way that trademark law works, they turn out to be a little bit of an abuse or a manipulation or possibly a gaming of the system. Before I talk about a couple of the cases, I want to talk to you about the problem that these things are causing us. So in theory, trademarks should be easy. I pick a name, I pick a goods and services, I check whether someone else has got it. They don't, so I go and file my mark and I launch my business, and I'm safe in the knowledge that I've protected that name and I can stop anyone else from copying me. And when I talk to entrepreneurs or startups and small businesses and people who've never been for a trademark clearance project before, that's kind of what they're hoping I'm going to say. But it's nowhere near as easy as that, unfortunately. And there's a number of reasons. So the first one is the number of trademarks. We get more and more every year. I've got some statistics. So up here you've got the number of EU trademarks and UK trademarks applied for every year between 2010 and 2020. Blue is the EU. So you can see a clear trend there. We get more of them every year. Then we have the number of trademarks in force. So green is EU and red is UK. And again, that's going up and up, pretty sharp in the EU. The UK figures don't include the effect of Brexit, which we'll probably see a huge spike there. But it's a clear picture. We get more and more trademarks every year, so that means more and more words, more and more goods and services are taken, are monopolised. At the same time, our language is evolving, of course, so we do come up with new words, but I don't think we do it at the same pace that we're seeing trademarks being registered. So naturally, we are running out of words. If we keep going in this direction, there won't be any left to trademark. It will be impossible to find a new brand. So we've shifted, probably in the last decade, from a position where I might do trademark clearance for a client to find them a new brand, do the clearance, and not uncommon to come back and say it's fine, there's no real issues. We've shifted from that to it being rare and exceptional for me to come back to a client and say, you're all clear, there's fine, there's no issues. There's almost certainly going to be at least one issue, there's probably going to be a handful, and there may be more. So it's more just now a question of, well, how bad is it, how many problems are there? That's made worse in the UK and EU because of the way we draft lists of goods and services in trademark. So there's no incentive against throwing in pretty much everything. You can put in thousands of words that no human could readily absorb. You can throw it all in, grab whatever you like, and the trademark officers don't care. It's all fine. Then we have what is, in my view, a quite pro-trademark owner judicial system. So the EU IPO loves finding confusion. It's a pretty low bar. The UK IPO is a bit more conservative. But from the High Court's perspective, there's a number of decisions in recent years where I'm quite surprised that they find confusion. And actually, overall, it's not uncommon for me to look at a decision and think, if I'd looked at that before there was a decision and was advised on it, I wouldn't have thought that that would conflict it. So I'm surprised to see that. We also have a 5-year non-use period for UKTMs and EUTMs. That means that I can, under that practice of grabbing pretty much everything, secure a monopoly for a 5-year period, which in the modern world is an age, maybe it always was, but it's a big monopoly. Then there's a software problem. So software is now everything. Nobody really sells software, but they'll sell you a service with software in some way. They'll have an app. But the classification system doesn't deal with that properly. So I can claim a monopoly in the term software or software as a service, and I can do that for that 5 years. So it's a huge potential monopoly. The end result of all those things is a mess. It's now pretty much impossible to do proper clearance for a new brand without spending a lot of time and a lot of money, or just saying, well, I'm going to have to take these risks and see what happens. That's all the more so if you're in the area of technology or if you have software or an app. So we go from this perception that perhaps some people would have that I can just go and buy a trademark, it's going to be easy, to it being far more complicated and painful than that. That's great for us lawyers because there's lots of work for us to do, but it's not really good for anyone else. And it's not a big business versus small business. It's not like this is great for the big brand owners and the small guys coming in struggling. It's bad for anyone who's innovating. So people who are building a new business, launching new products, coming up with new sub-brands, they're the ones that need this to go well, and they're the ones who are going to suffer. The only people that benefit other than the lawyers are probably the old established brands that aren't really doing anything new. They're just trying to protect what they've got. And perhaps a system that is in favour of those rather than innovators is not a good one. So that's a summary of all the problems. Let's look at a few of the causes in more detail. I'm actually only going to look at 2 cases because that's more than enough in the time that we've got. Skykick and the Monopoly case, or Hasbro. Skykick considers how much can I take, and the Monopoly case asks whether I can keep taking it over and over. So I've got a real challenge actually covering this in just a few minutes. There's already been 9 judgments, and there's an application for permission to appeal to the UK Supreme Court. If you don't want to listen to me speak for a couple of minutes, you can read this slide, which is a list of the 9 judgments that we've had. I'm going to give you the barest summary of Skykick that I can manage. So most of you will know that Sky is a TV and broadband company. It has very broad trademark specifications. In Skykick, one of the trademarks is 8,255 words long, which is about 10% of the first Harry Potter book. Probably not nearly as interesting. They include broad terms like computer software, telecommunications, and also some very random terms like tuxedos, wind turbines, and toilet articles. And Sky uses those trademarks. It's very litigious. It's probably the most prolific trademark litigator in the whole of Europe. And it spends millions a year suing everyone who uses the word Sky. Skykick is a cloud IT service provider and one of the victims of Sky. And Sky sued for trademark infringement back in 2016, I think. And they won in 2018, subject to some important questions that then went to the EU Court of Justice. The first question was whether if you use imprecise and unclear terms like computer software, does that give a ground for invalidating registration? And the Court of Justice said no to that. It's a pretty clear no objection, so end of that one. The questions that are still being fought over concern bad faith. So is it bad faith for me to apply for lots of different things that I have no intention of using, cram them all into thousands and thousands of words in a spec? And if so, should the whole of my registration be invalid or just parts of it? And the Court of Justice said that, yes, that can be bad faith in the right circumstances, but it would only affect part of the registration. So the case then comes back to the High Court. The judge is Mr. Justice Arnold, as he then was. He'd already indicated when making the reference that he thought that Sky was up to no good, so he did find bad faith, and he cut down several of the broader terms that Sky had protection for, including computer software, and he cut that down to sort of computer software for the particular types of things that Sky does, so like TV and entertainment. But that didn't actually make any difference to the outcome. Sky still won. The only consolation prize that Skykick got Well, because Sky was acting in bad faith, the judge said that they couldn't have their costs. It was about £1.5 million that they would have expected to have been paid by Skykick as the winning party. So they lost out on that. That takes us on here to number 7 and 8. So we're in the middle of July 2020. So go a year ahead of that into July 2021, and both parties have appealed, and a Court of Appeal gives a judgment, led by Sir Christopher Floyd. And to the surprise of many, the court overturned the trial judge and concluded that, so far as the goods and services that were relevant to the Skykick or potential Skykick infringement were concerned, the allegation of bad faith that was made against Sky was that it was only applying to use for certain types of software, not all types of software. And the Court of Appeal said that's not bad faith. And the Court of Appeal also said it's fine, well, it's not relevant if you file for 1,000 items, that one of the particular items is in bad faith. So that's a controversial judgment. We have a High Court judge who found as a fact that Sky were doing things that they had no commercial rationale for. And then we have the Court of Appeal effectively shrugging their shoulders and saying, well, it's fine. And in my view, that's effectively giving a thumbs up to the kind of practices that have caused the problem that I've just described. Skykick hasn't given up. It sought permission to appeal to the UK Supreme Court. As far as I know, there's no answer to that request yet. It's supported by at least 7 preeminent professors of IP and trademark law. And I do hope the Supreme Court will hear it, because as things stand, the Court of Appeal was sort of enabled the fill your boots policy that we've had for quite a while here, that is, unless we do something about it, only going to make the problem worse and worse. So that's Skykick. Monopoly is a little bit more straightforward. So Skykick looks at what can you grant for the first 5 years when your mark is not subject to proof of use. And that 5-year period is a very powerful stake of the trademark, because all you need to do to enforce it is effectively waive your trademark registration at somebody, and then you're done. And as soon as you get past the 5-year point, it's a lot harder, because you have to prove that you've used your mark. And even worse than that, if you can't prove it, somebody can attack your mark and you lose it. And brand owners don't like having to do proof of use. It's costly, it takes time, it involves them getting together material that they just don't have in the business. But it has to be done properly. It's like a forensic exercise. And there was a case that McDonald's was involved in where they lost a Big Mac trademark at the EU IPO, probably because they didn't do that proper exercise and maybe assumed that because it was a well-known mark, it would be fine. So businesses don't like it. So why don't you just file a new trademark every 5 years? So you never have a trademark that's more than 5 years old. That's called evergreening. And in Monopoly, Hasbro essentially admitted that that's what they were doing. And they said, well, everybody does this, and it's easier than having to prove use. We're just going to keep filing new marks. And the EU General Court said, no, you can't do that. That calls to mind an abuse of law. It meant that Hasbro's later filed EU trademarks were invalid because they were filed in bad faith to the extent they duplicated the early ones. So they didn't lose all of their rights, but it meant they'd have to fall back to the older ones, and then to rely on those, of course, then they had to prove use. That decision was appealed to the Court of Justice, but that court refused to hear it at the end of last year, so we won't get another judgment on that case. Apparently it wasn't convinced by Hasbro's arguments that this is an important enough point. That seems surprising to me, because clearly it's an important point. But if we end up with a decision from the General Court that says you can't copy and paste your spec every 5 years, then that's probably a sensible conclusion. But I don't think it's the end of the story. You can see Monopoly as having quite a narrow application. So you cannot file for the exact same mark with the exact same goods and services over and over. But it doesn't say you can't file for a slightly different mark or slightly different goods and services or a combination of those. If I update my logo every 5 years with a slightly more modern design and then refile that, is that okay? Does that still kind of effectively evergreen me with periods of non-use? I don't think we have a clear answer to that yet. So back then to the problem. So the Court of Appeal says you can file for whatever you like as long as you're going to use some type of it. You can take the whole of computer software for 5 years without having any commercial rationale, and you can file for thousands and thousands of words. That's all fine. Maybe we can only do it once, according to Monopoly, but possibly if we're clever and we adapt things every now and then, we might be able to perpetuate what we're doing. Now, you can sense that perhaps I'm critical of the Court of Appeal judgment, but if we actually go back to the High Court decision, it doesn't solve all of our problems, because by the time we got to number 7 on the list, all that Skykick had achieved was to narrow down a few of the 8,255 words, having spent about £1 million or £1.5 million on doing so, and is still lost. And the effect really was that the only penalty for the bad faith, even under the High Court judgment, is you get pared back to the goods and services that you probably should have filed for at the beginning. So there's little to no incentive to do that from the start. You might as well just start with an encyclopedic spec that you can thump somebody with for your first 5 years, wait for someone to challenge it, and then maybe you might have to narrow it down, or maybe you just stop challenging and make a settlement. There's no incentive under that judgment to not do this. So do we have any solutions? It's a multifactorial problem, so we probably need to come at it from a few angles. We need a different decision in Skykick, so maybe we'll get the UK Supreme Court looking at that. Clearly, we have one of our most expert trademark judges, Mr. Justice Arnold, as he then was. If he thinks you're acting in bad faith, you'd think there should be some consequences. I'd also be tempted to go further than he did on perhaps striking out the terms that were applied for in bad faith rather than narrowing them down, just to look at whether we can have a harsher penalty for acting in bad faith, other than perhaps costs. We should also change our classification system, so I would ban software. I would not let you apply for software. I'd let you apply for types of software, and as many as you like, but you've got to apply for them in the classes that are relevant to service. So class 36 for banking software, class 43 for hotel reservation software. That way you have to file in multiple classes, it's going to cost you a bit more, and I think the likelihood that you then apply in every class for every type of software is probably going to be drastically reduced. I'd be interested if anyone has any flaws in that system, because I'm sure there's some problems with it, but I think what we have now is broken. I'm not sure I prefer a US-style prosecution system, so those who've had any experience of it will know we get a very easy ride here. We just file for whatever we like. At the USPTO and in some other trademark offices, it's much harder. You will be asked to go line by line through your spec and make amendments and narrow things down. And you can't get away with anything like what we do. Maybe we can meet somewhere in the middle between those two systems. I also think we might need to narrow the scope of protection of trademarks. And I think there's lots that judges and hearing officers can do on that front. So we can start asking, maybe be a bit more tighter about whether we think there's actually genuinely a risk of consumer confusion. This is all supposed to be about protecting consumers. Are they really going to be confused between the two, or can we allow them a bit more attention in distinguishing? I've seen a number of cases where I think we've gone past, we've got the balance on the wrong side of the line. American Eagle and Eagle Rare is a recent case about whiskey, where the Court of Appeal upheld the trial judge finding confusion. And that's an example where I think we've just got it on the wrong side of the line. And part of the problem is that there's so much law in trademarks, but actually it ultimately comes down to a judge's decision on the facts and weighing up the marks. And so it's quite hard to appeal, which is part of the problem that came across in that case. So you do have one bite at the cherry, and I think the judges need to be a little bit more conservative about finding confusion. I also think that marks that have descriptive or non-distinctive elements, or that have only just sort of got over that line of being slightly distinctive, should be given a narrow scope of protection. To some degree they are, but I think there should be a clearer principle on that. If you have managed to scrape your mark over the line, it's got descriptive or non-distinctive elements, you should find it very hard to enforce it. If we do all of those things, or some mix of them, then I think we will be able to balance away from a system that probably is in favour of greedy trademark owners and those with the most resources. And we might bring things back a little bit towards consumer protection focus and a business fairness sort of focus system. But we've got a little bit of work to do. That's all from me.
Thank you very much. We've got pretty much the 20 minutes for questioning that we had planned. So I'm going to invite questions now. I don't know, how can we pick up questions from the Zoom element in the... Right, but how do Zoom participants signal their presence? Or maybe it's not a real question because there aren't any Zoom questions. Would you let me know if there's a Zoom question? Okay, all right. So for the moment, staying within the people in the room. Questions? Gosh, the only 3 questions in the same row. What are the chances?
It's a plant.
3 people and a plant, apparently. So going from left to right.
I mean, I do have sort of questions for all of you, but I think, just for the sake of brevity, just sort of going to ask one question for Lisa, because I actually thought it was quite interesting how the sort of USPTO now seems to have switched, found sort of a new argument to actually sort of refuse registration for sort of these marks, which, sort of in the past would have been found to be sort of disparaging or sort of problematic on other grounds that now have been struck down. And sort of all the examples you were giving us have had to do with sort of registration for goods that I think is very easy to see how they sort of perform some form of expressive function, so sort of many features, and I'm guessing sort of probably mugs to sort of those kinds of goods. And my question to you is, are there any examples that you're aware of, sort of outside those types of goods, like computers or sort of furniture, chairs, where we could actually see that, maybe that is extending to sort of other types of products? I mean, you may not be aware because it's maybe sort of still a little bit early, but I mean, I'm wondering what is the reaction from the sort of trademark community, but sort of I'm thinking more about practicing attorneys and sort of brand owners, sort of what is their reaction to this way of sort of, bypassing sort of what the Supreme Court said in sort of Tam and also during that too.
So I'll start with your second question first, as commentators often do. So I think a number of attorneys have supported the use of failure to function doctrine because they agree that it's anti-competitive. If you're talking about expressive merchandise like apparel, things like that, to give one company exclusive rights to use a political, phrase. So I know after the Elster case came out, I was thinking, this should be refused registration on failure to function grounds, even though you're not striking it down on these other grounds. And so the examples that I showed you, I forget if it was the swastika case or one of the other cases, that was an argument that was made, is that this is going against Ham and Bonetti by not registering these marks. But the Trademark Office was very clear about the fact that those rulings just focused on the fact that you couldn't use the disparagement or scandalous or immoral mark provision to refuse registration. But that doesn't mean you don't have to satisfy all the other requirements in the trademark law, like distinctiveness, right? It has to be, non-functional, and it has to function as a trademark. So I think there are definitely some folks that were kind of frustrated that this new doctrine has been evoked in these kinds of cases, but I think a lot of attorneys that I've talked to and scholars are fine with this new approach. But I think your first question of, has there been applications to register like fuck for refrigerators? I haven't heard of it, and I think a lot of times people want to register curse words or other kind of shocking messages or political messages for what I call expressive merchandise. And so I think that context is so important in trademark law. So I'm opposed to registration of common phrases for expressive merchandise, like lifeguard, for example. But I have no problem if someone wants to register lifeguard for calculators, right? So I think that it's critical if to not just think about all registrations, we shouldn't allow it. I think that some of these disparaging, scandalous, immoral terms, it might be fine to register. I mean, fine to me, but it might be not refused registration on failure to function grounds because it's not expressive merchandise, for which they're seeking the mark.
Yeah, I guess this is for everyone, but I guess maybe primarily for Jonathan, just on the grounds that my familiarity with U.S. constitutional law is very out of date. Over 15 years since I've studied any U.S. constitutional law. And the question is, the short version of the question is, if under that second step, there's never any cases we can find where refusing the trademark would violate freedom of expression rights. Because you mentioned it's unlikely. What then? Do we kind of go, let's scrap this, or should we get rid of this? And the reason I ask that is because, I personally think, we've got ourselves in such a muddle. I think we're going to continue getting ourselves in a muddle. You take a mark, you get someone who's trying to register an offensive term. You have two options. deny the registration, you know, that has arguably a negative impact on freedom of expression, arguably, as Simon Tatton would say, okay? Or alternatively, you could register the mark. But then that might potentially, arguably, limit the freedom of expression of people coming later. It's something that Lisa has said. And also you have to confront Lisa's other argument that, well, you know, you could still use this. The feeling I get is, this is just a wash. You're damned if you do, you're damned if you don't. I mean, you can do one thing or the other. You can register the mark, you cannot register the mark. Neither has a clearly beneficial or detrimental effect net when you take everything into account on freedom of expression. I think you should just, you know, I just don't think it's just irrelevant. I mean, there are some cases where it becomes relevant. Dilution is the example where it is actually relevant. But when it comes to the offensive, is this mark offensive, and does registering an offensive mark in freedom of expression? I think it's somewhat irrelevant, and I think that's why in the judgments where they said you should take it into account, I think the reason they've been so vague about what take it into account is because the judges who've written this don't know what that means either. It sounds like something we should take into account, doesn't it? It sounds, freedom of expression, that sounds really important. We should take that into account.
It is important.
It's right, yeah, but I think that's why it's just because even Justice Arnold in FC UK, he starts out part of his judgment saying, I'm confused with what I'm meant to be doing about this. It seems contradictory. I think we should just give up and just say, look, the freedom of expression thing, forget about it.
Look, I'm not at all unsympathetic to that point of view. I mean, that effectively motivated my first adventure into the thing. I mean, I think it gets far too much attention. We've spent quite a long time talking about it and listening about it. There's lots of writing on it. It's not banning a book, is it? Refusing to register fuck as a trademark. I mean, it clearly isn't significant in that way at all. I think the difficulty is that when you apply the rules, the principles, as it were, of freedom of expression law, free speech law in the States as it's developed, then it's difficult to avoid the conclusion that it is relevant in a way. And we're left, I think, trying to find ways of escaping that situation, because it's difficult to think of cases in which, you know, we might want to rely on freedom of expression to save something effectively. And I think your description of what courts are doing very often in paying lip service effectively to the principle, I think that's exactly right. I think that is what happens. But given that they would like to escape that and have acknowledged that they can't do that, we have to find a system of dealing with that. And I rushed at the end of what I was saying because I was conscious I was running out of time. And I think there are a number of different ways of doing that. One might be that we abandon the effort completely, okay? I think that's difficult to do if we're to live in a world of fundamental rights principle. Another thing might be to do what was suggested to the Advocate General in Constantine Film, which is that you somehow use this to exercise a bit of leeway for the applicant. But that's unsatisfactory, I think, really. Because particularly coming out of Constantine Film, you get a very strict view of what violation of accepted principles of morality actually is. You know, it's said to be, you know, this is something that throws into question the fundamental principles of society. How are we going to have flexibility in deciding that? That seems to me implausible. I think when it's being used somehow to influence interpretation, that's just decoration. I don't think it's happening at all. I'm a little bit sceptical about my two-stage system, but I do think there are possibly a couple of instances in which it might happen. So, for example, one might be if we follow Constantine Films and we say that effectively you have to take into account a majoritarian approach as to what is against accepted principles of morality or not, if that's what we have to do, there might be situations in which, nevertheless, in the interests of avant-garde art or something like that, which is strongly protected within the convention, we might still want a mark to be registrable for that particular use and in that context. And a failure to do that may not honour fundamental principles of freedom of expression law about creativity and artistry. But that might not work. We don't know if we have to employ a sort of empirical majoritarian approach to the principles of morality or not, and I suspect courts will try to avoid doing that. But that might be one instance. But I don't disagree, but I just don't think we can be as cavalier as you're suggesting, unfortunately.
Yeah, and I'm actually going to disagree with you. I don't think it is a wash, right? So you have the registrant's free speech right that's arguably harmed by not registering it. And then you have everybody else, right? Not just one person. You have a number of companies, individuals, organizations who are selling identical goods for identical marks, but also different goods, right? Or using similar marks. And so I think the right to freedom of expression weighs heavier on the side of not registering than in registering.
I would add a controversial viewpoint, which is possibly just let almost everything in. Obviously, if it's not distinctive, it doesn't work as a trademark. That's a fair basis anyway.
Right.
But you could just let everyone register fuck if they want. There'll probably be a flurry of them, and everyone get bored of the joke. And then we don't have to make the difficult choices.
I think that's right.
Decide who.
Yeah. Do we want government employees
who
deciding
decides
what
the
is and is not okay? And I personally don't. But so I can understand your opinion.
And I'm not sure that's what I think should happen, but it's an option.
Yeah, it's an option with fuck, but it might not be an option with other things that people might
Hate speech,
see.
yes.
Yeah.
Well, that's the challenge. I think
Well,
you have different
yeah.
categories here, the curse words versus the hate
I think
speech.
you could also look at the market, because how many people would buy Hitler coffee or whatever it is? I suppose there's a risk that by allowing
Sadly,
people to register
there are some
it,
people
you're
that
sort
might,
of-
but yes.
if you register it, you're sort of giving a tacit approval to that brand.
Well, and that was the
that's-
argument, is that there was some sort of government approval. And I think you could just educate the public that there's not, right?
Yeah.
That it's just a free-for-all.
It's
And maybe that's what
positive.
Twitter is going to be like now with Elon Musk declining it. But anyway.
Yeah.
Lorna,
Okay, so question for Jonathan and observation for Darren. That's okay. Question for you, Jonathan, is to what extent do you think you can see Constantine Films as part of a sort of free speech package with the copyright cases like Declan and Pelham and things like that, or is there something a bit special for trademarks? And the observation for Darren is just about the sort of like locating software within classes. I wonder, just off the top of my head, if maybe there's some kind of analogy with packaging, where often marks are registered for packaging, but the registration is in the class where the packaging is going to be used rather than for packaging, although sometimes they are registered for packaging.
It's just a classification issue, I think. Some of these classification probably needs to be changed. I don't know who you would write to about that.
Well, it's technical experts function. So you start by writing to the technical expert desk at UKIBO, and then they pick it up when they next meet at Whitehall, because there are annual meetings of technical experts from every country that uses the international.
Must be jolly, those meetings.
Yeah, I can imagine there's a lot of committees that would have to get through.
Oh, it's very important and interesting to know where smartwatches go. Is that 14 or is it 9? But the packaging all falls in class 16. So if you're Tetra Pak, that's where you would be selling your Lads Pack Miller. Sorry, I didn't want to break into your question there. It was just that the thing about computer software is that if you were a software service company in 42, you'd still have a right to have all that software. So it's not so much the software in the industry, but rather the function of the software. Is it an app? Is it an accelerator? Does it help store? Does it help recover? All that needs to be broken down as well. And I don't think that is even done at the USPTO as well, because they're sometimes very happy to accept computer software all in relation to financial transactions. What does it do? Is it a payment processor? Does it help with encryption? What? And if you go back to, I forget if it's the Court of Appeal, whether it's the trial, but someone is pointing out, well, that's not good. All relating to financial is still not going to give you a clear and precise list of your software. So that is something that most judges in IP would support, be they patent people or trademark people. You've got to be very clear now about what type of software you want and what does it do. Yeah, I'm sorry, I didn't mean to.
We should be, but at the moment we don't have to be. I think that's the problem.
The fat-headed Court of Appeal. Providing you want to sell a bit of software, you can have all software.
Yeah, which is like saying you can have like
Well,
world
I don't
commerce.
think, I mean, I hope they give leave, and but they hear it. Because the worry is, you look at it, if they get leave, if I was Sky, I'd do a deal.
But isn't part
You
of
can
the
keep the
problem,
judgment then.
yeah, but isn't part of the problem the fact that at trial, and there's a lot of cross-examination on, why, Mr. So-and-so, do you have bleaching preparations in your specification of goods? You're a telecoms company. And there was no cross-exam on why do you have computer software when you're owning a telecoms company? So I have some sympathy with the Court of Appeal for that, and again, I didn't mean to interrupt so often, but if we could just go back and start again.
Perhaps he should answer it.
Sorry.
So, on your question to me, Ilana, yeah, they are part of a package, and I think the package is an enormous and comprehensive one, and I think we only view it as a package because we're intellectual property lawyers. What the court is doing in both of those instances, it's functioning as a general court, effectively a constitutional court, and we just see its impact in those particular cases. And I think in a way, that's the beauty of having a general court. I know there are lots and lots of advantages of specialist courts in IP, and this is discussed and researched and so on. Of course it's right, but it's also really important that a general court gets to look at IP disputes in some instances, because they're aware of the constitutional structure. And what's really notable, I think, in Constantine Films is that it was the Board of Appeal and the General Court who were utterly adamant that trademarks and freedom of expression had nothing to do with one another, because they could see that would be a massive nuisance, and I guess, like the previous point, it would get us nowhere. Once you get to the General Court, they realise that actually can't wash if we view the law as an integral structure, effectively.
I think we have to wrap up now. I want to thank Jonathan Griffiths, Lisa Ramsey and Darren Neal for first-class presentations. I'm just sorry that we run out of time. I had 3 questions I wanted to ask and didn't want to abuse my position as chair, so perhaps on another occasion. But thank you very much, and congratulations.